I'm Pam Masters, and I'm a collaborative family lawyer, which is to say that I'm a settlement specialist, and I guide couples and families on the difficult journey of divorce without court involvement. I do this in ways that protect children, preserve financial assets, and create healthy co-parenting relationships. Today I'm going to talk about the most common things that my clients learn from the internet that are just plain wrong. And I'm talking about these today because so many of these things cause unnecessary anxiety and worry at a time when there's plenty of that to go around. I'm going to tell you 5 things, the 5 most common. Number 1, that if you move out of the house, you've abandoned your interest in the house. Nothing could be further from the truth. When and how the house was purchased is the primary factor in determining whether the house is a marital asset. If your living situation has become too toxic or stressful, you may remove yourself from the home, and it will not affect how the home is distributed in the divorce. Number 2, and related to this first one, is the idea that if the house is titled in only one spouse's name, the other spouse has no interest or right to the house. Again, how the house is titled is not the primary factor in determining either whether it is a marital asset or how it will be distributed in the divorce. It also doesn't determine who's on the mortgage. The deed and the mortgage are 2 separate documents. Somebody could be on the deed and not on the mortgage, and vice versa. Number 3, that one parent or the other will have custody of children. Florida does not recognize custody of children. In Florida, there's parental responsibility, which is about making decisions about the children, and time sharing, which is about where the children will be spending their time. Neither parent will have sole custody of children. One parent may have more time with the children, or one parent may have ultimate decision-making authority over certain areas of the child's life, such as education, medical, or religious decisions, but there is no such thing as custody in Florida. Number 4, that if the parent's income is equal and time sharing is equal, neither parent will owe child support to the other. And related to this, that online child support calculators are accurate. Child support is based upon, first, what the legislature has determined is the cost of raising a child given the combined incomes of the parents. That's the starting point, the number that the legislature deems appropriate. Then other things besides percentage of income and overnights is factored in, such as the cost of each parent's health insurance, the cost of daycare, the cost of health insurance for the children, and who's paying it. And last but not least, number 5, that there's a formula to calculate alimony. There is no formula used in Florida. For several years, the legislature attempted to pass a formula, but the law was never signed. In Florida, alimony is based on the recipient's need and the payor's ability to pay. There are several factors listed in the statute that go into this decision, but there is no formula. I hope these help. As always, I'm happy to answer your questions personally and would love to talk to each and every one of you about any of these things. I can be reached at 386-271-8044, and there's tons more information about these myths and other things on my website at www.masterscdc.com.